Hello everyone, welcome to your lordships. So again we are going to discuss the your lordship MCQ series, and we are going to discuss the questions of CrPC again, which are generally asked in Uttarakhand prelims exams or RJS or UP exams and any other exams. So let's start with the MCQs. Now the question is, which one of the following statement is correct? If a person forcibly resists the endeavor to arrest him, the police officer may. Now this question has been asked in 2015 UP PCSJ exam. Now the options are: use all means necessary to effect the arrest, cause the death of such persons irrespective of the offence he has committed, cause the death of such person accused of murder, cause the death of such person accused of culpable homicide not amounting to murder. Now let's see the answer, and the answer is A, that is use all means necessary to effect the arrest. And what is the explanation? Where is it given somewhere? Any of the provisions of CrPC? Yes, it is given in CrPC section 46 clause 2, and now in the new act in BNSS section 43 clause 2, you will find that it is given how arrest is made. Arrest how made, and there it is written that CrPC 46(2) deals with the manner in which arrest may be effected, particularly when a person forcibly resists arrest or attempts to evade it. And it says that the police officer may use all means necessary to effect the arrest. So that is why the correct answer is option 1. Let's see the next question. Next question is that in which one of the following sections of CrPC it is mandatory to produce the person arrested before the magistrate within 24 hours. Now this question has been asked twice in UP PCSJ exam 2006 and 15. Now let's see the options. And options are section 51 of CrPC, which has now become 49 of BNSS, section 56 of CrPC, section 57 of CrPC, or section 59 of CrPC. These are a little confusing, but you have to just remember the section and you will get the exact answer. Let's see what is the answer of this. So answer is section 57 of CrPC, or now in BNS section 58. So option C is correct. Now see the explanation for the same. Now what are the explanation? Section 57 of CrPC that says, no police officer shall detain in custody a person arrested without warrant. Without warrant. Now this is important. For a longer period than under all circumstances of the case is reasonable, and such period shall not, in the absence of a special order of a magistrate under section 167, exceed 24 hours, exclusive of the time necessary for the journey from the place of arrest to the magistrate's court. So it clearly says, excluding the journey part, somebody has been arrested from one place and he is being produced before the magisterial court. Excluding those duration of journey, the police officer cannot detain a person more than 24 hours. Let's see the next question. Question number 3 is, provisions relating to health and safety of arrested person have been provided under which one of the following sections of Criminal Procedure Code? It has been asked in UP PCSJ, Uttarakhand PCSJ 2002, 12 and 19. And options are section 50A of CrPC, which has now become 48, section 53A of CrPC, which has now become 52 of BNSS, section 55A or section 60A. Now let's see the correct answer. Correct answer is section 55A of CrPC, which has now become section 56 of BNSS, that is option C. So let's see what is given in that section. What is the explanation? It provides that section 55A, it shall be the duty of the person having the custody of an accused to take reasonable care of the health and safety of the accused. So this is clearly provided in this section, and that is why this option is correct. So let's see the next question, that is question number 4. The provision of examination of arrested person by medical officer is provided under which section of the code of criminal procedure. Again, this question has been asked in Uttarakhand prelims, UP judiciary prelims. These are the sections: section 53, which has now become 51, section 54, 55 or 60. These are very easy questions because they are directly based on sections. So if you memorize the section clearly, you will get full marks, you will score 2 marks. See the correct answer is section 54 of CrPC. So 54 clearly provides that examination of arrested person by medical officer, and this is given in the clauses. So this is very easy, directly just section number you need to memorize. See the next section: under which section of CrPC a police officer can arrest a person without an order from a magistrate and without warrant? Again, this question has been asked in Uttarakhand and UP-PCSJ. These are the options: section 42, section 40 of CrPC, 51 of CrPC and 41 of CrPC. Now see the correlated or the corresponding sections of BNSS also. Probably in RJS the questions might be asked on BNSS. So 42 corresponding section is 39, 40 34, 51 49 and 41 35. Okay. Let's see the answer of this question. Answer is section 41 of CrPC, that is section 35 of BNSS, and see the explanation what is given in that. It says that when police may arrest without warrant. So this is very clear, again very easy based on just the section number. Let's see the next question, that is your question number 6. A memorandum of arrest of an arrested person is required to be signed and attested by one member of. Now in RJS it has been asked twice, in 2011, 2018. Now see the options: his family and one of his relatives, the locality and members of the locality and one of his relatives, member of other locality and one members of his family, member of his family and one member of the locality, and the counter signed by arrested person. Let's see the correct option. Correct option is D, that a memorandum of arrest of an arrested person is required to be signed and attested by one member of his family and one member of the locality and countersigned by the arrested person. So see the explanation, where is it given? So this is given in section 41B of CrPC, procedure of arrest and duties of officer making it, and here it is given that it will be attested by at least one witness who is member of the family of the person or the respected member of the locality where the arrest is made, and countersigned by the person arrested. So this is clearly given in that. Let's see the next section. Next question is, which one of the following is correctly matched? This is again asked in UP-PCSJ. Section 44 CrPC, which has now become 41 of BNSS, when police officer may arrest without warrant. Section 42, arrest on refusal to give name and residence. Section 41, arrest by magistrate. Section 43, arrest how made. Now see the answer. The answer is that 42 does not provide arrest on refusal to give name or residence. So 42, that is option B, is the correct option because this is not correctly matched. Now see what does it provide for. Section 42 provides arrest on refusal to give name and residence. So this is section 41, when police officer may arrest without warrant. 43, arrest by private person and procedure on such arrest. So that is the justification. Again, it is simply section and heading based questions which have been asked in your Judicial Services Examination. Let's see the next question, that is question number 8. A proclaimed person whose property has been attached can claim property or the proceeds of the sale on appearance. This has been asked in Uttarakhand Judicial Services within 6 months, within 2 years, within 3 years, within 1 year. Let's see the answer. Within 6 months, that is option A. Where is it given? So that is given in section 84 of the CrPC, which has now become section 87 of BNSS, and it clearly says if any claim is preferred to or object made to the attachment any property attached under section 83 within 6 months from the date of such attachment. So claims and objections to attachment which states, right? So basically this section provides that if there has been any attachment to your property of the proclaimed person, so he can claim that property or proceeds of that property within 6 months. Let's see the next question, that is question number 9. It says, in order to compel appearance of a person who is absconding in spite of warrant of arrest being issued against him, his property may be ordered to be attached simultaneously with the issuance of proclamation under section 82 of CrPC, provided that the court is satisfied that such person is, again it has been asked in Uttarakhand prelims exam. Let's see the options. About to dispose of the whole or any part of his property, about to remove the whole or any part of his property from the local jurisdiction of the court, either condition in A or B exist, both condition in A or B coexist. Let's see the answer. Answer is C, that is either condition in A or B exists, that is he is about to dispose of the whole or any part of his property or remove the whole or any part of his property from the local jurisdiction of the court. Where is it given? Let's see the explanation of this answer. So, this is given in proviso of clause 1 of section 83 of CrPC. So, again it is very clear that the court, where the time of the issue of the proclamation of the court is satisfied by affidavit or otherwise that the person in relation to whom the proclamation is to be issued is about to dispose of the whole or any part of his property or is about to remove the whole or any part of his property from the local jurisdiction of the court, then in that case court may order the attachment of property simultaneously with the issue of proclamation. So, it is very clear, it is again given in section 83. Let us see the next section, that is question number 10. A proclaimed offender whose property has been attached, can claim back the property or sale proceeds on appearance before the court, that is within 6 months, within 1 year, within 2 years, within 3 years. This question has been asked in RJS as well. So, answer is within 2 years of the attachment. Now, see the difference. A proclaimed offender, this is not a case of attachment. Proclaimed offender whose property has been attached can claim back the property or sale proceeds on appearance before the court within 2 years. Where is it given? Again it is given in clause 3 of section 85, which has now become section 88 of BNSS. Let us see the next question, that is question number 11. Which provision of the CrPC resembles with the habeas corpus writ? It has been asked in UPPCSJ in 2006 and 18. Section 91 of CrPC now, which has now become 94. Section 93 of CrPC, which has now become 96. Section 97 of CrPC, which has become section 100 of BNSS, or section 96 of CrPC, which has now become 99 of BNSS. Let's see the answer, that which section resembles with the writ of habeas corpus. So, the answer is section 97 of CrPC, which has now become section 100 of BNSS. So, what does it provide for? It provides that 97 of the Code of Criminal Procedure 1973 is often referred to as mini habeas corpus, as the search warrant issued under this provision closely resembles the writ of habeas corpus issued by the High Court or the Supreme Court. It is used to secure the release of the person wrongfully confined, ensuring protection of personal liberty by directing authorities to locate and produce the detained individual before the court. So, it is similar to habeas corpus. That is why the correct answer is section 97. Let us see the next question, that is question number 12. Section 91 of the CrPC does not apply to, it has been asked in 2012 of Uttarakhand Judiciary exam. Options are: section 91 does not apply to the accused, to the complainant, to the witness, a person who is neither a complainant nor an accused nor a witness. Let us see the answer. The answer is the accused. Option A. Now, why? Because it says summons to produce document or other things, and in case of Shyam Lal Mohan Lal versus State of Gujarat 1963, the Gujarat High Court held that the provisions of section 91 of the Criminal Procedure Code do not apply to an accused person, as compelling the accused to produce document or things may cause grave hardship and result in an unfair investigation. the court emphasized that such an application of section 91 would be inconsistent with the principles of a fair trial and protection against self-incrimination. So this is section 91 of CrPC, which now has become 94 of BNSS. Let's see the next question, that is question number 13. On a declaration of forfeiture of a book by the state government under section 95 of Code of Criminal Procedure, the application to set aside lies to thee. So this question has again been asked in RJS 2016, that on a declaration of forfeiture of a book by the state government under section 95 of Code of Criminal Procedure, the application is to set aside lies to. आप किसको देंगे ये application? The options are district magistrate, chief judicial magistrate, district and sessions judge, high court. Let's see the options. Yes, D is the correct option, that is high court. And where is it given? Let's see the explanation. And the explanation is given in section 96 clause 1 of the CrPC, which has now become section 99 of BNSS, and it says any person having any interest in the newspaper, book or other document in respect of which a declaration of forfeiture has been made under section 95 may within 2 months, this is also important that you need to remember, within 2 months from the date of publication in the official gazette of such declaration, apply to the High Court to set aside such declaration on the ground that the issue of the newspaper or the book or other document in respect of which declaration was made did not contain any such matter as is referred to in subsection 1 of section 95. So this is very clear that section 96 clause 1 provides that you may apply to set aside such books or publication under section 96 to the High Court. Let's see the next question. The next question is question number 14. Obligation of person making arrest to inform about the arrest, etc., to nominate person is provided under. This has been asked in West Bengal Judicial Services. Section 54 of CrPC, which has now become 54 of BNSS, Section 50 of CrPC, which has now become 47 of BNSS, Section 50A of CrPC, which has now become 48 of BNSS, and Section 53A of CrPC, which has now become 52 of BNSS. Let's see the answer. The correct answer is C, that is Section 50A of CrPC, which has now become 48 of BNSS. Let's see the explanation. What is given in that? So it provides obligation of person making arrest to inform about arrest, etc., to the relative or friend. So it is directly given in this section, that is section 50A. Let's see the next question, that is question number 15. It says that in which of the following cases the Supreme Court has issued the specific guideline regarding the arrest. Now this question has been asked in Bihar Judiciary in 2000. Let's see. Vishakha versus State of Rajasthan, A.R. Antule case, D.K. Basu's case, or Nandini Saptapati case. Let's see the correct answer. The correct answer is D.K. Basu's case. The explanation is that in D.K. Basu versus State of West Bengal 1997, the Supreme Court laid down the specific guidelines with respect to the arrest. Now there are some proposed questions which might be asked on the basis of the new law, that is Bharatiya Nagarik Suraksha Sanhita, that is BNSS 2023. So we have also incorporated those questions, probable questions which might be asked. Let's see the question on BNSS specifically. Under the Bharatiya Nagarik Suraksha Sanhita 2023, the term designated police officer is defined under which of the following sections? Which of the following sections it has been defined? Options are section 35, 36, 37, 38. When we are saying 35, 36 of BNSS, of course, these are the proposed questions which might be asked in your examination based on new laws. Let's see the correct answer. Correct answer is section 37, that is option C. And C, what is given in that? Section 37, which was earlier 41C of CrPC. It provides for designated police officer, and it says that the heading has been changed from control room at district courts to designated police officer. See the next question which might be asked on BNSS, that under BNSS 2023 within how many hours must a private person hand over an arrested person to the police or nearest police station. Options are without unnecessary delay, within 6 hours, within 12 hours, within 24 hours. Let's see the answer. The answer is within 6 hours. So, if a private person has arrested someone, that arrested person need to be produced before the police or the police station within 6 hours. Where is it given? What is the explanation? So, that is given arrest by private person and procedure on such arrest, that is section 43 of Code of Criminal Procedure, which has been renumbered as section 40 of the BNSS. So, it clearly provides that without unnecessary delay, but within 6 hours from such arrest, within 6 hours. The next question is, which is on BNSS, as per the proviso to section 54 of BNSS, the identification process involving a disabled person must be. The identification process involving a disabled person must be written and signed by the officer, conducted privately without recording, supervised by a DSP, recorded using audio, video, electronic means. Now see the option and the answer, that is written and signed. So the fourth option is correct, that is recorded using audio, video, electronic means. Where is it given? See the explanation. So that is given in the section 54 of the BNSS, which was earlier 54A of the CrPC. And it is specifically provided that identification process shall be recorded by audio, video, electronic means. Now see the next question, that is question number 19. Under section 71 subclause 1 of BNSS 2023, a court may serve a witness summons in which of the following ways in addition to and simultaneously with regular service. See the options: by oral communication, through local police station, by electronic communication or registered post, by public announcement. Now the answer is C, that is electronic communication or registered post, along with the summons. In addition to the summons by way of court, the courts may send the summons by electronic communication or registered post. See the explanation, is it given anywhere? Yes, it is given in section 71 of BNSS, which was earlier section 69 of CrPC, and it says the word summons to be served by electronic communication. The last question of this series is, under section 35 clause 7 of the Bharatiya Nagarik Suraksha Sanhita, no arrest shall be made without prior permission of an officer not below the rank of Deputy Superintendent of Police if the offence is punishable with imprisonment of more than 7 years, less than 5 years, less than 3 years, more than 3 years. Let's see the correct answer, less than 3 years. If there is less than 3 years of offence that has been committed, so arrest can only be made with the prior permission of a police officer not below the rank of Deputy Superintendent of Police, or you can say the ACP. Where is it given? Let's see the explanation. When police may arrest without warrant, which is given under section 35 clause 1 and 35 clause 2 of BNSS, which was earlier section 41, and it clearly says that no arrest, 35 clause subclause 7 clearly says no arrest shall be made without the prior permission of an officer not below the rank of Deputy Superintendent of Police in the case of an offence which is punishable with imprisonment for less than 3 years. So here it is written less than 3 years. So 35 clause 7 provides that if offence that has been committed is punishable with less than 3 years of imprisonment, so no arrest can be made without the prior permission of the Deputy Superintendent of Police. So friends, we are providing these MCQs for your upcoming examinations, which are very helpful. and we are also providing the MCQ series on the other subjects. So, for more information, please subscribe our channel and visit to our website yourlordships.in. Thank you so much.